Good morning to the West Coast participants and good afternoon to East Coast participants. I'm Robert L. Matthews. I serve as the Chief Program Officer for Think of Us. Thank you for joining us today. I would also like to thank Dr. Sharon McDaniel, who's the CEO of A Second Chance, Inc., and Sixto Council, who is the CEO of Think of Us. This will be the third of four series of our Hidden Foster Care series, which today will be legal rights and protections for kinship caregivers, parents, and young people. The goal of the session is to explore the legal rights and protections of kinship caregivers, parents, and young people, a vital conversation for families, advocates, and professionals committed to creating a more supportive and kin-first child welfare system. It is also important to ground us with a particular definition around hidden foster care, which refers to informal kinship care arrangements where children live with relatives, family, friends, or community members without formal child welfare system involvement or legal custody orders. These arrangements often occur when families attempt to keep children safe and together while avoiding the formal foster care system, but caregivers typically receive no financial support or services despite providing full-time care. Just a couple of housekeeping. We want you to be extremely engaged throughout this webinar. So if at any point you have any comments and or questions, please use the chat function, which is at the lower part of your bar. We will have individuals monitoring throughout the webinar. We may have opportunities during the webinar to answer them, but we will leave time, maybe 10 or 15 minutes toward the end to be able to engage and answer some of those questions. I want to take this opportunity to introduce and give a short intro and bios to our esteemed panel today. Allison, who is the Chief Legal Officer at the National Association of Counsel for Children, manages the organization's policy advocacy, oversees amicus work, and provides training and technical assistance to child welfare practitioners nationwide. Allison previously served as a Foster America Fellow at Missouri's Children Division and a senior supervising attorney at the Children's Law Center in Washington, D.C. Josh is a clinical professor of law of Columbia Law School, where he directs the Family Defense Clinic. With his students, he represents parents in cases alleging neglect in New York Family Court and administrative proceedings to clear parents' names from the state's neglect and abuse registry. And Heidi is an associate director of the American Bar Association's Center on Children and the Law. Heidi directs the ABA Center's work on kinship and state projects. She helped develop and co-manages the grandfamilies.org, a national website of kinship laws and resources in partnership with the Casey Family Programs and Generations United. I would like to welcome our great panel today. I'm going to ask each of them to introduce themselves and share how the topic of legal rights and protections for kinship caregivers intersects with their professional work and experiences. We'll have Allison go first, shortly thereafter Heidi and Josh, and then I'll come back for a series of questions for our panel. So Allison, take us away.
Sure. Good afternoon, everybody. It's great to be with you. At the National Association of Counsel for Children, our focus is guaranteeing high quality legal representation for children and parents who are involved in the foster care system. Of course, the foster care system has traditionally been thought of and is a social work discipline, but it is also a civil rights space. And to navigate it properly, children and parents and kin need proper legal advice. Over the last few years, I think nationwide, we've seen a really great movement towards prevention, moving upstream, and agencies attempting to do safe reduction. And at the same time, through our organization, we've heard thematic concerns about states about, well, how can this play out on the ground? What do these conversations really look like? How does it experienced when a youth is diverted by the youth, by their caregiver, by their parent? So we've been participating for several years in a coalition along with Heidi and Josh that you'll hear more about. And that's what brings me and my perspective to today's panel. And I'll pass it to Josh.
Thanks, Allison, and thanks, Robert, for hosting us. And I hope everyone who's in the middle of the heat dome is staying cool. So I'm a lawyer and a law professor. I represented children some years ago in Washington, D.C., and now represent parents through my family defense clinic. And when we talk about hidden foster care, we're talking about families in which CPS agencies are intervening and are pressuring families to have some kind of separation between the parents and children. And then the most important orientation that I have is something that I think, as Allison was just describing, has become a starting point consensus in our field that children generally do best with their parents, and they should only be separated from their parents when absolutely necessary for their safety. And my sense as someone who represents parents will shock nobody. I think that is far less frequently than the current system separates parents and children. So when we're talking about hidden foster care, my first concern is having checks and balances on what the agency is doing and the pressure that the agencies are pushing on families to separate. Because I don't want the trauma to children and the trauma to parents of separation to happen unnecessarily. And I want parents to be fully empowered to make choices for their children and to do so voluntarily and not through coercion, because we know that, and what the law's starting point is, and what I think the empirical evidence starts us with, is that children do best in their parents' care and that parents are entitled to make decisions for their children. And I'll pass it to Heidi.
Thank you, Josh. My name is Heidi Rudlish-Epstein from the American Bar Association Center on Children Law. And the work we do as the nonprofit arm of the American Bar Association is really looking at access to justice for children and families. So as Allison mentioned, when we talk about child welfare, we're really thinking of a social work and legal field and how those intersect. And my background is I'm actually a lawyer and I have my master's in social work. So kind of coming at it from both ends really led me to kinship. And so my work at the ABA is predominantly focused in other platform portfolios as well, but on kinship care. And I've been fortunate over the years to work with great partners like Think of Us, Generations United, Casey Family Programs, and Annie E. Casey Foundation to look at what we can do to empower kinship caregivers to have the information they need to make informed decisions. Josh talked about fully empowered choice, and I think I come at the perspective of hidden foster care as the most important thing is that fully informed choice. And in order to make that empowered choice, it needs to be informed. And in order for it to be informed, really looking at who can help all three, the children, the parents, and the kin, think through these legal barriers and complications in the system as we approach hidden foster care. So I appreciate being asked by Think of Us to sort of talk about this very topic.
Thank you, Allison, Josh, and Heidi. Allison, you mentioned the move that the child welfare field is making in terms of prevention and moving upstream. And Josh, you talked at length about ensuring that, removals are done only when they're absolutely necessary. And Heidi, you talked about ensuring that, it's done so in an informed way. But how does the agency and the system, how does it really strike the right balance that when children and families come to the attention of the child welfare agency, what is it that the agency should be doing to ensure that families do have choice and decision in that and ensure that they're supported? And so I'll start off, Allison, with you. Allison, you're muted.
There we go. It said host will not allow you to unmute. So, well, there are several things. For what I want to begin with is saying that I don't think, speaking for Heidi, Josh, or myself, what we don't advocate for is that every child should just come into foster care. I think that's been a misconception sometimes with this term hidden foster care, where people say, oh, you just want all children to come into the system. That is absolutely not our end goal. Our end goal is to support families being able to safely make plans for children that might involve diversion, but plans that they're empowered to make, that they feel they have full information about their legal rights, the legal benefits, the pros and cons. One of the best ways to do that is by having access to counsel at that pre-CPS stage for everyone involved. Social workers are going to be there during an investigation, bringing their social work lens, what their expertise is, identifying issues, bringing in resources, maybe pulling family together in a meeting. But each of the players in what we might call the triad, the youth, the parent, and the caregiver, has some unique rights that might be at stake. Parents have rights. Kinship caregivers need to have information about what placement of the child with them may mean, pros, cons, benefits, and I'll speak specifically to youth as well. I think in the context of hidden foster care, there's been some misconceptions that, well, how could youth have access to counsel during this time? Youth are not, property who only have rights that turn on at age 18. Rather, youth do have rights that gradually and incrementally increase as they age in their teenage years. Some of those are constitutional, for example, sexual and reproductive health rights, but many of them are state specific and statutory. So, for example, depending on a state where a youth may live, they might have earlier access to being able to consent to a medical treatment, dental treatment, vaccines if they want to be vaccinated, reproductive and sexual health care, getting a work permit, a driver's license, or even immigration relief. And a youth is entitled to have access to that legal information so that they know how this agreement, whether we call it diversion or safety planning, is going to affect them. So I think one of the things that child welfare agencies can do in helping to implement these arrangements is to embrace and bring in pre-petition counsel for everyone involved.
Thank you, Allison. Josh and Heidi, do you have any insights?
Yeah, I would love to say a couple of things. So your question, Robert, is what should agencies do? And I think the first thing I would say is that agencies need to recognize that there is not a universe in which they're going to be interacting with families in which coercion is not possible, if not likely. Agencies have tremendous, tremendous power. They have the power to destroy families. They have the power to create new families, and every family that is on the receiving end of a CPS intervention knows that, right? And that creates power. Just as there was anytime the police stop someone on the street and say, "Hey, would you like to have a purely voluntary consensual discussion downtown?" Right? There's a power differential there. And if we want to make sure that that the person has a voluntary choice to say yes or no, we've got to do something about that power differential. So that would be my message for folks on this webinar who work at agencies, right? That power differential is there, and we've got to be wary of coercion. So even if it seems voluntary, that doesn't mean it is truly voluntary. That doesn't mean that the parent on the other side who is signing the forms that you're putting in front of them is experiencing it as voluntary. Doesn't mean the removal that you may think they're agreeing to, I think they're being coerced to agree to, is a voluntary or a necessary one, or that they're agreeing it. So they may well and very likely are not feeling a real choice. How do we level the playing field and correct that power imbalance? And Allison talked about it. Having access to an attorney is one of the ways our legal system provides everyone a little bit extra power when the government's teeing off with you and investigating you and initiating something. I will emphasize something I think a little bit differently than Allison did, and I'm sure Allison you'll expect this. Allison described rights to counsel for everyone in the triad, right? The parents, children, and kin, and we're focusing on the moment when children are living with parents. Parents have full custody rights. And the state is intervening, right? And if this is a three-legged stool, it is not, the legs are not even, right? Parents have the most rights. Parents have the rights to the care, custody, and control of their kids. And that's why it's so the essential first step is to give parents counsel in that situation so they can push back against the agency and say, hey, you've got your facts wrong. Or, hey guys, I practice in family court, you practice in family court, you know the judges here are not going to sign off on a removal here and push back. Or counsel their parents about what their options are if what I just said is not the case.
And we hear from a lot of people with hidden foster care about the coercion with parents, and that is absolutely the case. There is no question that power differential just exists. But I want to point out the power differential that happens when someone asks relatives to step forward with no notice, no support, and no resources. There is that coercion and feeling from a relative's perspective that if they don't step forward in these sort of hidden foster care situations, that these children are going to end up with a stranger, end up in foster care, end up with different kin perhaps. And if they have a split-second decision to make, and they have to make that decision right now, there's also that feeling that if they say no for whatever reason, they will never be considered. And it happens if the child were to enter foster care, they will never be considered a viable or appropriate resource for that child because they said no at that moment at 2 o'clock in the morning when someone was trying to create that safety plan or do that family arrangement. So thinking about coercion on so many different levels and to kind of right that power differential is information. You know, that saying that information is power. And so who is it that can step in and provide that information? And as Allison pointed out, the ramifications of their choices. What are the rights? What are the responsibilities, not only of the parent and the caregiver, but of the agency in that kind of situation? And in order to spell all of that out and to have sort of a true meeting of the minds in a family arrangement, number one, it has to be in writing. In many places, it's not in writing. It has to be time limited because these ideas that we're stepping in to assist is supposed to be short term. So it should have a time limitation. So things like in writing, time limitation. I know we're going to talk about data later, but so that it is clearly spelled out. So families really know what they're entering into. It all comes down to families making a choice about, because they are an expert of their own, what's best for them. But in order to make those choices, they really need that support and to understand what the impact of their choices. And that's sort of where attorneys come in. And I know in the chat, and I think we could talk about this in a few minutes, there's been information about, well, how do we fund those attorneys? How do we support those attorneys? I know Allison gave some resources, and we have some on grandfamilies.org as well that talk about pre-petition Title 4E preventive representation for the parties. And so that is it's been around for a while, but the federal government came out pretty strongly a few years ago to say that this is something that your state should look into. So, you know, I don't want to go so far as to say attorneys are the answer to everything, even though I'm from the ABA, so I suppose I'm supposed to say that. But they certainly do help. And I think the biggest piece is, what does informed decision-making look like for the families would really help.
Thanks, Heidi.
Sure.
Allison, at the top of your last statement, I think was really profound and interesting because there, I believe, are some myths in terms of the hidden foster care movement, as they call it. You said, we do not advocate that all children should be placed in foster care. And I think that is an important statement to make because there's a belief that this movement is trying to push that children far better in foster care when we know the data or the research shows differently. You also mentioned the importance of having legal representation at the point of when a family comes to the attention of the agency. Josh, you talked a lot about leveling the playing field, and Heidi, you came back and talked about the power of information. And so what I want the three of you and kind of push you to probably provide some recommendations. Let's say right now in reality, and we know this happens, majority of our public child welfare agencies do not fund legal counsel at the point of when families come to their attention. And so as you talked about, the potential of coercive actions or techniques taken can be likely. But if we know right now in the current field where that legal representation doesn't exist, what are some things, though, that the agency can do until or if they get that type of support for families on the front end? And you can go in any order.
Great question. So I think the overall point here is we all believe in prevention and keeping children out of foster care, and that's an excellent goal, but it cannot be a goal that exists in a policy silo. It needs to be part of a larger policy package that supports families outside of foster care. So the most simple example is in many places, kin who might be ready, willing, and able to accept a child temporarily face a choice when they say, well, if we go through foster care, I'm going to get a stipend and I need that money because I don't have the income. I wasn't expecting overnight to have a new child with, with medical needs and put more food and clothes on the table. There are some places where can access a stipend or can access a smaller amount through TANF, but it is very irregular and nationwide there is not parity. So one thing kind of system-wide we can think about is leveling financial incentives so that families don't need to make these choices based on money and will they be able to make ends meet and put food on the table, but they can make the best decision for themselves based on the best interest of the child and the family.
And I agree with Allison. It's that inequity that you have to enter the system in order to get the supports and services. So to me, that is the biggest thing that can be done is build up the services and supports outside of child welfare in a way that's not your only choice to receive assistance. There are a few states that do, as Allison mentioned, they have, enhanced TANF, or they have subsidized guardianship for kin who don't enter the system. So looking at how we can sort of balance the inequity of what we call informal kinship caregivers, those outside the system with those inside the system. One program that works in some states to at least get back to that informed decision-making is kinship navigator programs. And so I think the biggest thing that we can do is support our child welfare staff to know about these resources, to know about the supports that are available, and to be able to give that information. Because in the scenario you're painting, Robert, there isn't an attorney to come in. So what's the responsibility of the social service agency? It's for them to understand what supports and services exist outside of child welfare and connect the families to those services, whether it's connecting the parents, the kin, or the child. But first, we have to make sure the services exist, and then we have to make sure the knowledge is there to connect them to those services, which is where things like a kinship navigator can come in quite handy.
So I agree with everything that Allison and Heidi have said. I also want to fight the hypothetical a little bit, Robert, because the question is, we know that lots of agencies don't fund preventative legal services lawyers for parents. So what can agencies do? Well, agencies can start funding that, right? Title 40 dollars are available for that. Counsel for Parents is an empirically established intervention that helps. And from an agency's perspective, it gets kids out of foster care and saves them money without putting them in without having any worse safety outcomes. And we should expect similarly positive outcomes for first and foremost for parents and children, and secondarily for agencies if we start providing counsel for parents at that stage. There are places that have started to do this. This is not pie in the sky stuff, not anymore, right? Washington State, hi Marcy, I see you on my Zoom screen. The Office of Public Defense have started getting some money from the Washington legislature a couple of years ago. They run a hotline for parents. So when the Washington agency pushes parents to sign on to voluntary placement agreements is what the jargon they use there. And the parents can call the Office of Public Defense and they get counsel to advise them, right? And Marcy and her team have put together some preliminary data about the work that they've done over the last year or two, and it's pretty impressive. A healthy percentage of the parents that they work with end up not entering those VPs, and their children stay with them. So what can agencies do? They can talk to their legislature and access some of that dollars to fund some of that same service together safely.
Thank you, Josh. I want to go deeper with this particular section because All of you said some very insightful things. One, Allison, you talked about it shouldn't just require financial incentive, right? And that's not the way that the decision should be made. And Heidi, you talked about ensuring that there's equity and that, perhaps what are those supports outside of child welfare? And then Josh, you just mentioned, sure, they can just fund it. I want to better understand that if a public child welfare agency could fund it, what would be the distinctive role and function of that attorney? Because what we also find is that even when families or parents may have an attorney at the point of when they come to the attention of the child welfare agency, there are differences of opinion in terms of the role of the public child welfare agencies, whose role is to ensure the safety of the child, versus the role of the attorney. So can you all talk to me about what some of those role differences are, and then how do they cooperatively have a conversation about the care of a child?
I think you raise a good point, Robert. And, we always hear these sort of offhanded comments that if you bring an attorney into the situation, it's going to get that much more complicated and that much more contentious. But a good attorney is not just what you think of as a courtroom attorney. A good attorney also has the role as a counselor, and they counsel and provide advice and information. And so, again, sitting down and saying, is this what's best? And it's possible that a parent attorney would sit down with their client and say, you know what? This is better than having your child formally removed and having an adjudication of abuse or neglect against you. But the parent in that moment can't really understand the difference. And so having somebody sort of talk them through, this is what can happen if you go this path, the same with kin and children, this is what's going to happen if you go that path. So it's that role of counseling, advising, and supporting. I think another nice piece of that preventive legal advocacy is that we're not just talking about having an attorney help you with child welfare. They might be able to help you get in better housing. They might be able to help you with an education issue you're struggling with. If we're talking about a child coming to the attention of child welfare because of educational neglect, perhaps they need assistance in advocating for their child's educational needs. So their attorney can link them to that educational resource. So it's really kind of looking at it as a more holistic use of an attorney and not what we normally kind of picture of everybody fighting in court.
And I'll add a couple points to that. One is multidisciplinary law firms, right? The gold standard for representation is a team where there's a lawyer and a social worker or a parent who has lived experience who can talk to the parent client. If the parent is interested in services but is a little ticked off at the way she's been treated by the agency, they can work with a multidisciplinary team to access services. And the non-lawyer members have a host of other roles we could do a whole webinar on. I also just want to underscore how difficult the decisions are that have to be made throughout the life of a hidden foster care case, right? First is the question of whether a parent-child separation needs to happen, right? Is there abuse or neglect going on at all, right? Is it so severe that the harm of separation is worse than the harm of whatever is going on? What steps can be put in place to keep the parent and child together, and is the situation such that separation is the only way to protect the child from harm? Then the questions only compound as we go further, right? What should the parent-child visitation arrangement be? What does the parent need to do to get their kid back? Okay, they've done some of the things on the list that the agency provided, but have they done all of them, and is it enough, right? And the role of an attorney is essential at each of those stages. One, because checks and balances are essential, right? Because of the power differential we discussed earlier, right? And because of the fundamental nature of the rights involved. And as Heidi was saying, a really good attorney will know when to say, okay, agency, look, you asked her to do 3 things. 2 of them are really connected to the reason we're all here, and she's done them. And the 3rd thing's extraneous, and I'm going to push hard to get the child to end the safety plan, get the child home today, right? And to know when to counsel their client and say, you know what, if we take this to court, here's what based on my knowledge and expertise and experience is likely to happen. And at every stage, that role is essential.
I'll just add a few other things to Heidi and Josh's excellent comments on the role of an attorney here. One is that the attorney may be able to provide legal advice that a social worker couldn't and shouldn't. Social workers have so many responsibilities and tasks that are expected of them. And they cannot and should not be expected to know all the legal alternatives. So, for example, in many places, we see hidden foster care show up in other courts, in probate court, or what's called domestic relations court. And in other courts, they may be entirely unfamiliar with. So, one role of the attorney is to kind of expand the view for how this case fits into a larger system. Secondly, Josh talked a little bit about how the decisions start compounding. Having an attorney involved in looking at these diversion plans can really help make them successful by avoiding conflict and confusion up front. So, for example, if a young child is placed in a kinship arrangement, who's going to be taking that child to the doctor? Who's going to be consenting to a medical treatment if they need it? The attorney can help advise what rights do you have or not have, and let's get that all clear up front to avoid unnecessary conflict between the parties. And then lastly, what the attorney does that no one else can do is provide a confidential space for the parent to speak freely. And I cannot emphasize enough the importance of confidentiality because of everything we've already talked about, the stigma associated with foster care, the fear, the coercion, the power imbalance, the sacrosanct nature of the attorney-client relationship means that there is going to finally be a space where a parent may be able to voice concerns or problem solve something that they would not be able to tell a social worker because they logically know if I tell a social worker they're a mandated reporter and I might be worried. Attorneys create a preliminary space to sort through concerns. And the Children's Bureau actually issued wonderful guidance on this several years ago that said the attorney-client relationship allows a space for concerns that would otherwise go unvoiced. And that's what I think attorneys provide, a space to learn more, to let's bring everything to light and create a solution that's really authentic to the problems at hand, rather than just a Band-Aid.
Thanks, Allison. I'm going to now turn to a couple of questions in the chat because it's pretty interactive there. And I'm going to ask a question from Cindy. She says that she does work with Latino immigrant families in Baltimore, and she would especially like to learn about the legal rights of children and families with a mixed immigration status. This can mean a child who is a U.S. citizen and a parent who is an immigrant at risk of deportation.
I can't speak to the law in Maryland. I'm not a Maryland attorney, so I want to be clear about that. I'm a New York attorney, and we've done, and there are legal services groups that have worked with mixed status families here. And the starting point of that work is that parents have a right to decide what's best for their children, right? And so if there's a parent who is undocumented, is worried about getting rounded up and deported, and they were trying to figure out where their child should go in that situation, they have the right to make a plan. And different states have different rules. In New York, they can make a plan that is instantly revocable, keeps the power with parents where it usually belongs. That would designate someone temporarily to be able to have temporary, essentially a custodial power of attorney over kids, and take care of them in the short term, and depending on what the parent wants, either keep them here in the U.S. or arrange to have the child reunified with the parent somewhere else. What I worry about with those arrangements is pressure if CPS agencies are involved, then we get into hidden foster care situations and pressure from agencies on families. We could, of course, have a whole long webinar on the harms of family separation through ICE enforcement. That's probably a conversation for another day, though.
And I just want to point out, we put some resources in the chat because we have several colleagues at the Center on Children Law who work on those very questions of the sort of intersection of immigration issues and child welfare. So hopefully some of the information we put in the chat will be helpful. I know we often look at sort of the immigration status of the child and of the kinship caregiver when we're thinking of how we can best be helpful to support families as we kind of navigate these very complex waters right now. I hope those are helpful resources.
Thank you, Josh and Heidi. I'm gonna go back just for a second because in kind of the last segment of our discussion, there seemed to be some tension between the Public Child Welfare Agency and what they call not necessarily agreeing with the clinical judgment that they make in terms of whether or not to bring a child in or out of foster care, and the discussion that they may have with a family and or parent who is represented by counsel, and how those things can be navigated or resolved. I'm just wondering if any of you have had any experiences with that and may want to speak to it.
Well, this is the nature of the work, right? I mean, that's the nature. It's a good question, Robert, but it's not a question that's unique to just hidden foster care. I mean, that question is what we're all embroiled, any practitioner is embroiled in about when can the child, if the child's been removed, after, when can they turn home? This is when can visits safely begin? When is it safe to begin unsupervised visits? That exact question and tension is kind of inherent to our discipline. And we have to learn to kind of speak one another's language, learn one another's tools and resources. This is one of the reasons that I know all three of us, advocate for multidisciplinary representation, as Josh said, so lawyers can have that advice from that clinical advice in their ear. And it's also one of the reasons we advocate that for lawyers, they should not just be trained in the law. They need to be trained in the trauma of removal, social science, cultural humility, all of those best practices. And in the same vein, social workers, have disagreements amongst themselves. I think I don't want to speak for the whole profession, but I've worked with many social workers over the years who can look at the same family and have a different clinical take on what should happen. And that's okay. That, these are complex cases. Families are complex, and just embracing that, not, in a personalized way, but in a professional way, and bringing the best research we have to bear, and most importantly, bringing the voice of the family about what they think, because we can all come in and say, well, the study says if we send this kid home, blah, 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 what happened. But parents and youth and kin know the family best. They know what's going on day to day. I want to highlight, there was a great comment about, the concern about GALs in this context. And I'm not talking about bringing guardian ad litem or best interest attorneys into this context. I'm talking about lawyers who represent what youth want and need, so they can talk about safety concerns with their lawyer as well. So anyway, I think it's an important question, but it's a question that applies to the field as a whole, not just to this aspect.
And I think it can be tough to look at what has to happen at a systemic reform level versus individual cases and make sure that there's not a disconnect. Because again, as Allison said, we can all come up with these great ideas, but if we're not listening to the people who are actually in the field, and I'm talking about those who've been impacted, but I'm also talking about the caseworkers. So really supporting those who are working in the field, the judges, the attorneys, the caseworkers, what support do they need? What do they need to do their job better? So when we're talking about systemic reform, that it doesn't all fall to blaming the agency, because that's really not going to get us to move the dial if we're thinking about what kind of change we need to make. And I think the biggest thing that anybody working in this field or living in this field can do is ask questions, because that pushes people to not just rubber stamp things, that pushes people to not just accept the status quo. This is what we've always done. I never want to, to me, that is not an acceptable answer to any question. We're doing this because this is what's always done. So just questioning everything.
Thank you, Heidi. I'm going to shift us just a bit because a lot of what we've talked about in terms of this hidden foster care versus kinship care in the formal sense, we can't really track what that looks like across the country. So I'm wondering if you all can talk about the critical importance of data tracking and the transparency that's needed. related to this topic.
Absolutely. So when we use the phrase hidden foster care, I think the word hidden means two different things, right? These cases, these family separations are hidden from due process checks and balances that we've been talking about since 2 p.m. They're also hidden from legislative oversight because in most states, and under the federal data tracking requirements, state agencies are not required to count how often they separate families in this way. And they're not required to track the demographic, the racial disparities, class disparities in the families that are separated in this manner. They're not required to track what happens to these kids after they're separated from their parents, how many go home and how quickly. How many are the subject of some later petition, neglect petition in family court? How many are the subject of some custody or guardianship petition, or some other outcome? And these are essential questions to evaluate how this is working and what should be done about it, whether the solution in one jurisdiction might be to abolish this practice altogether. In another jurisdiction, it might be something different. We need data to show that. A couple of states, I'll give, and this is I think a bipartisan point, Texas, and a couple of years ago, enacted a data tracking bill as part of its CPS reforms, that I'm sure many folks on this call are familiar with. And the New York State Legislature just this session enacted another data tracking bill for hidden foster care in New York State that's now on the New York governor's desk and will hopefully be signed. And also cautiously optimistic and hopeful that sometime in months we'll have a federal data tracking bill that would require this of all states. I think the bottom line from my perspective is if you're using your agency power, your state power to separate families, the least you can do is count when you do so and track what happens with the kids to inform further conversation about what we ought to do about that. A version of that bill was introduced by Senators Cornyn and Ossoff, again bipartisan, towards the end of last year, and we're hopeful that they will renew that push in the coming year. And if with apologies for jumping on a soapbox, for all of you out there who are advocates, we'd love for your ability to sign on to that if and when we get to that point of having a bill. Sign on as in endorse and push Congress to enact a strong data tracking requirement.
I want to just add one piece to what Josh is saying, and I think that as you mentioned, the data is really important. It's important because when we ask states if they do this, they say no. No, we don't do this. So that's the first piece of it. And the reason that some of them say no is, and not with ill intent, because there's lots of different terms that get sort of mingled together: kinderversion, safety planning, hidden foster care. So the need for sort of defining these terms and understanding that you could be in a state that they all occur, but they all occur differently. So I can be in a state that does safety planning, does hidden foster care, does family preservation, and does kinderversion. And they could all mean something different. So when we're looking at collecting data, it's incredibly important to define the terms of what we're collecting data around and understand that there are times that they are intersecting terms. But that is really important to get the data we need. And the data will help inform any kind of reform or support that's needed. I just wanted to point that out, that these bills are great, but it takes and it forces people to step back and define those terms. That's another reason that collecting data works. Now, data is only as good as the people entering the data, but it is better than what we have now, which is nothing. So.
There was a question in a chat about, is there a way to ask your state, for this data? I will point out that the Annie Casey Foundation released a series of reports on this, and they've done a lot of the legwork for you there. They did, make requests from various states. You can go through those appendices. Those reports are pretty recent. They were all released last year. Additionally, one of our partners, Diane Redleaf, has been working on another report that will be forthcoming this year, where she did deeper dives into certain states. And so that's another resource that you can look out to. Of course, you can always try to do a Freedom of Information Act request or something of that nature, but we have found it's really difficult. And rather than reinventing the wheel, I'd urge you to look at that series of Annie E. Casey briefings on this issue.
Thank all of you. I really liked Heidi, as you mentioned, when we're talking about the importance of the data, the importance of defining it, because you're correct. When you look across the country and you use the words hidden foster care, safety planning, diversion, informal family planning, they all mean something totally different. And in order to get around some kind of universal data tracking mechanism or model, it will require, us to define those things. Within the last 10 minutes that we have, I would like to ask the three of you to think about, as we are in this space where there are children that come to the attention of the Public Child Welfare Agency and the work that they have to do to ensure child safety, and want to ensure that, families are supported, whether or not it is trying to support them in the community, or where children have to be legally removed and placed in the custody of the state or the jurisdiction. What is it that the system will need specifically in the community for those families where the agencies have made a decision that the current involvement doesn't warrant a removal? What is it that the system needs to ensure that these families are supported?
I want to just say, from a legal point of view, part of the lack of support becomes when there is that kin diversion, or the child welfare agency has left a child with kin with no legal relationship. Because if they have not have an established legal relationship through the court, then they have trouble accessing those services. So we can talk in a moment about what those services look like in the community, but I just want to also preface it by saying, without that legal relationship established, a lot of kin might not be able to access things like enroll them in school, get them medical care. It also fails to provide those supports or a clear path home to reunify with the parent when you do that kind of kin diversion. So I think your question's a good one about what does the community need, but I want to sort of step back a moment and say, if you're leaving a child with kin, yes, we need certain supports in the community, but establishing that legal relationship is critical first, because otherwise you can put the supports in and they can't access them. So I just want to sort of point that out, since we're talking about sort of legal ramifications in this webinar. But in my opinion, with the community, is everything that we would provide to a foster parent to care for a child safely should be provided to the family. And so I know that's a big, broad, sweeping statement, but I'm going to let Josh jump in with that.
Well, sorry to cut you off, Heidi. I'd like going to start where you ended. I'd like agencies to think about all the money that they would be spending in terms of foster care subsidies if a child was brought into the formal system, and think about spending all that money on ideally the parent, or if necessary, the kinship caregiver, to keep the child in the community and out of foster care, right? We need concrete supports. Yes, some parents will need services as well, specialized mental health care, substance use treatment, et cetera. Everyone on this webinar is familiar, I think, with the menu. Starts with spending some money on concrete supports. I think there is good reason to expect spending some money on counsel for parents will yield benefits. And I just want to underscore, Heidi, you talking about creating a legal status, especially when children are placed with kinship caregivers. I just want to describe how complicated that is, especially in a hidden foster care setting, because it can be the agency. I know you know this, Heidi, so this is really for everyone. We know the agencies are pressuring kinship caregivers often to file for custody and pressuring parents to consent. And those are cases where it should be beyond clear that we need to be providing counsel to make sure that those are truly voluntary actions, and that everything is getting surfaced that needs to be surfaced.
I agree with both those, and I would just add, I think what the community needs is really a shift in mental models to stop forcing unnecessary trade-offs in these situations. So, two examples. If a parent has their child go into a diversion situation, there are sometimes when it puts their entire housing voucher at risk because now there's one less person in the home. That's destabilizing the family, but that's the mental model that many cities and states are in. Oh, well, we can't give more; we have to make splits. Another old mental model is separating a parent and a child when there's safety concern, rather than bringing more resources in. Josh has written a great article about how to apply like lessons learned from other sectors to say, we don't need to do a separation. Let's let this family stay together, but bring a kinship caregiver into the equation to add to safety. So I think what the community really needs is shifting kind of old models where we forced trade-offs and separations and we build instead and add.
Okay, thank you, Allison, and thank you, Heidi and Josh. Thank you for really a robust discussion around legal rights and protections for kinship caregivers, for parents, and for young people. Right now, what we're going to do very quickly is we're going to load a particular poll for everyone to take. If you would take maybe a minute or two just to answer these questions, you should see it pop up on your screen. And as you do that, again, I want to thank this very esteemed panel, appreciate their participation, their expertise, and their advocacy around ensuring that caregiving families receive the legal protections that they need, and just in general around supporting families in the child welfare system. I want to let everyone know that the last series of our four-part series around the hidden foster care system will be in August, and we will have an entire panel of lived expertise to hear directly from people who have been impacted by the system. And they will just talk about their own experiences. Many of them have had experiences and issues around licensing. They've had issues of being supported. They've had issues of not receiving the financial support or the concrete supports that they needed to care for kids. And you've had some that have had actually good experiences. So we want to be able to provide a very well-rounded discussion on the positives and the not so good aspects of kinship caregivers who have come to the attention of the Child Welfare Agency when they make decisions and decide to step up to take care of kids. I also want to thank all of you for registering for today's webinar and appreciate your continued support. And hopefully something was said today when you can go back to your own jurisdictions and begin to broach conversations and the importance of legal rights and protections for kinship caregivers, parents, and young people. We're going to leave the particular poll up for the next 3 minutes. And again, I want to thank the panel and thank all of you for joining us today.